Everybody wanted him to land a really good blow.
93 days in the county.
Whoa, just stop talking, dog. Stop talking. I'm not thrilled with how quick that trigger was.
Go now.
On the other hand, maybe she could read it. Welcome back, everybody. Mark Breyer, the Husband Wife Law Team, a real-life certified specialist and trial lawyer. This is what I do for a living. I'm in the courtroom. So we're here today to go over some real-life courtroom stuff. By the way, thank you guys. So many of you are watching now. I really appreciate it. Please continue to comment and like. But here's the other thing. I just found out that only 5% of the growing number of people who are watching this have actually subscribed. Now, that's good, but it's not good enough. So quick, before we get into this, don't forget to subscribe. Let's get into the first one.
Charges assault and resisting. You have the
public defender Andrew Weinstock and his client are appearing before Judge John Murphy, whose voice you hear.
Public defender, what do you want to do?
Have they filed?
They have.
I'm not waiving.
All right, what do you want to do?
What do you want to do? I'm not waiving. You want to set it for trial, set it for trial.
Judge Murphy wants the defendant to waive his right to a speedy trial because the court's schedule's backed up. Weinstock isn't budging, and tensions are mounting.
The job of a lawyer is to advocate for their client within the rules of the system, to do it ethically, morally, and legally, not to make it easier on the administration of justice. That may make it unbelievably unfair to the judge. Then we need to hire more judges and get more court staff so cases can be prosecuted faster. It's inconvenient and it's expensive, but if you were accused of a crime that you didn't commit, you would want your right to a speedy trial. You'd want and expect and have a right to demand that your lawyer do what's in your best interest. Doesn't mean he has to be a jerk, doesn't mean he has to fight with everyone. Not in any way am I saying that. But the idea that he has to waive his client's right to a speedy trial because it's inconvenient for the court, I totally disagree with.
If I had a rock, I would throw it at you right now. Stop pissing me off. Just sit down. I'll take care of it. I don't need your help.
No, you know what? I'm the public defender. I have a right to be here, and I have a right to stand and represent my clients.
If you want to fight, let's go out back, and I'll just beat your ass.
They both head to the hallway behind the courtroom.
The first rule of Fight Club is you do not talk about Fight Club.
So I was all ready to tell you how wrong this judge was in every way. Then he said, let's take it out back and I'll whoop your ass. And I was gonna tell you even more. Then the cool, calm, collected lawyer goes to meet him out back. Wrong move. You were doing so well. Wrong move, because now you're both gonna get into it. Like now it's bad for both.
Just out of the view of the court's cameras. Believe it or not, they get into a physical altercation. Until Judge Murphy returns to the courtroom, alone.
Thank you.
Okay, everyone just clapped, and they're all wrong. This is like when the teacher makes a joke about a kid, and everyone laughs because it's the teacher, so you give the teacher credit. This judge is wrong. So look, the man's got power. Go ahead and applaud him. Maybe he'll help you out. Maybe he'll be better off for you. The judge started that by saying, I'm gonna throw a rock at you. The judge is the one who said, let's go and fight. And now suddenly the judge gets the round of applause.
Once Judge Murphy catches his breath, he continues with the rest of the hearings without Weinstock present.
Your choices, considering there's probably going to be a changeover in personnel, are setting it for trial June 9th, or if you were wanting to waive speedy, we would set it for July 15th.
I would like to get it done as fast as possible.
That doesn't help me.
That took courage. I don't know if the defendant knew that's what his lawyer wanted him to say, but that is what his lawyer wanted him to say. And man, the judge just fought your lawyer. So that takes guts.
The incident's investigated by the Florida Judicial Qualifications Commission, who charged Judge John Murphy with threatening to commit violence against an assistant public defender, engaging in a physical altercation with counsel, and resuming his docket while defendants were without counsel. The case eventually reaches the Florida Supreme Court, which orders the immediate suspension and permanent removal of Judge Murphy from his post.
That's the right answer.
When you're sworn in and you have to do a fitness test, is there a section on mixed martial arts or?
100%. You got to be brown belt or better to be an officer of the court. Look, I'm guessing that the lawyer got in trouble too. That's my guess, because he also engaged in a fight and he didn't defend himself. He walked out there. I feel kind of bad in that the man threatened him in open court. The judge started it, but it doesn't change that he absolutely made the wrong decision to go meet the judge out back.
Stand up and raise your right hand to be sworn, please. Please stand up.
Next, we head over to the Miami-Dade Bond Court in Miami, Florida.
The one sleeping there, you can wake up too in the back row.
Where Judge Mindy Glazer's overseeing bond hearings.
Thank you. I have a few announcements. I'm going to appoint the public defender to represent all defendants unless you tell me you have money to pay for a private lawyer or if you are hiring a private lawyer and one is here. Also, please let me know if you have served in the United States military or any of the reserves. Good morning.
Good morning.
Over the next few hours, she'll see dozens of defendants.
You were arrested for second-degree murder.
As they step in,
I'm in the military, Your Honor.
You are?
and quickly step out.
What would be the purpose of her asking to clarify if you were in the military?
So there could be a state law that I'm not aware of. It could be her preference in terms of how it affects her decisions on bond because there's an additional respect given to the military. Now, if you're active in the military, that's not what she asked for. That one defendant just said he's active. That could potentially impact things too. But the biggest piece is that either there's a law that requires it to be considered in bond hearings, or it's her personal preference that, hey, if you've served, I'm going to consider that when I decide what the bond is.
But the judge notices something familiar about this defendant.
Okay, Mr. Booth, I have a question for you.
Yes, ma'am.
Did you go to Nautilus for middle school?
Oh my goodness. Oh my goodness.
I'm sorry to see you there. I always wondered what happened to you, sir.
Oh my goodness.
This is the nicest kid in middle school.
Oh my goodness.
He was the best kid in middle school. I used to play football with him, all the kids, and look what has happened. I'm so sorry.
Oh my goodness.
The surprise reunion between the two former middle school classmates is almost too much for Booth to handle.
Oh my goodness.
Once a promising student, Booth fell into drug and gambling addictions that led him into a life of petty crime, resulting in multiple stays in prison.
Oh my goodness.
Good luck to you, sir. I hope you're able to come out of this okay and just lead a lawful life.
I just want to say this about our entire system. If we had more of that, we'd have better administration. If the police were in the community enough, and we don't have enough police to do that, to know who's who, and the people knew the police, and could generate trust, we'd have less situations where the good kid who does one bad thing, and in the old days was sent home to the family that was going to take care of it. You can't do that now. They might get sued. There's no trust between them. So the difference between the good kid who makes one mistake and the bad kid who just got caught, but everyone knows the bad kid, there's no difference now. They just get thrown into a system that runs them over. If the judges actually knew what they were dealing with, knew the people, then we would have a better chance at justice being justice. I'm not saying I have a solution, but imagine she wouldn't be, but if she was the judge on his case, she would see him as a person because they were friends. And she would understand he had made mistakes earlier, but she would judge him more neutrally than most of us judge someone who's just standing there in a jumpsuit arrested.
Have you ever been in court and you're like, oh wait, I know that person?
So I've had it with juries.
And that's obviously probably a conflict of interest, isn't it?
It's up to the judge. So I had a client that's still near and dear to my heart. She's passed away, Roxy. And Roxy became friends with Alexis and me, my wife and I. And so we knew her family. So I'm doing a trial and there's a girl in her 20s at that time on the jury. Hey, anyone know anyone? She raised her hand. Anyone know Mr. Breyer? So she raised her hand. Yeah, she goes, he's been over my grandma's house when I'm there. And then I knew who she was anyway, but in that moment I hadn't recognized her, so she said that. And the judge did take her off the panel, but if she had said it would not impact my ability to be fair and impartial, the judge may have left her on. So it's not an automatic disqualifier, but it's a potential disqualifier. Before I say anything, check out what I'm looking at. I don't know what I'm about to see, but here's my guess. This is going to be a verdict. And let me tell you why I believe that. You see the tables where the lawyers sit? You see how there's nothing on those tables? If you're in trial, your table is packed. When the jury goes out to deliberate, you take everything off the tables, you take it back to your car, back to your office, whatever it is. So when the verdict's read, you sit so much like they are, leaning forward. This is everything we've worked for, but the desk is empty because you don't need any of that stuff anymore. So watching this brings me back to some of the biggest moments of my trial career, just seeing everyone together.
We're now in the El Paso County Courthouse in El Paso, Texas.
That is a brutal moment with a little kid wearing a Free My Daddy shirt. I do a lot of life-altering cases, but not where people are going to prison because I'm an injury lawyer. Free My Daddy is a powerful thing. They probably would literally not allow that in the courtroom while the jury's actually hearing evidence. But because it's the verdict, by the time the jury walks in, they've already made their decision. But wow, I'm nervous now just knowing the verdict's coming. I don't even know what case I'm watching.
The attorneys for the state, the attorneys for the accused are present in the courtroom.
The man you see here is 41-year-old Daniel Villegas, accused of killing 2 teens in 1993 when he was just 16.
By the way, let me tell you guys something. See the lawyers on each side of this guy? You're like, well, they go home for dinner either way. He goes to prison or gets free, depending on this. Their hearts are beating through their chest. They've put so much into this. Obviously, they're not in the same shoes, but they are feeling it. This man's about to hear the answer that changes every moment of his life. Yes, by the way, we always talk about the person accused. On the other side are people who thinks he actually did it and is trying to get away with it. Their whole lives are affected by what this jury says now.
At that time, without an attorney or his parents present, Villegas says he was coerced by an El Paso detective into confessing to the murders. Despite recanting the confession hours later, it became a key piece of evidence for the prosecution. Villegas has been on trial 3 separate times for this crime and has maintained his innocence throughout. His first trial in 1994 ended in a mistrial due to a hung jury. A 1995 retrial ended with a conviction for capital murder, and Villegas was sentenced to life in prison. After spending 18 years in prison, that verdict was thrown out in 2013 because of ineffective assistance of counsel.
Isn't that something else? In the law, the same lawyer that's next to you, if you lose in a criminal trial, one of your best ways to get another shot is to prove the same person who's sat next to you wasn't just not good, but was totally ineffective. But it's really hard. There are people who've been convicted of murder and gone to jail for life, and sometimes actually had, in one case, sentenced to death. Their lawyer was asleep at the counsel table during trial, and it was not overturned. Imagine that your life is in jeopardy. Your lawyer falls asleep at the table, and that's not considered ineffective assistance of counsel.
And has remained out on bond as he awaited a 3rd trial. During that time, he fathered 2 children. Though the prosecution continued to insist on his guilt, there was no DNA, no firearm, and no forensic evidence presented linking Villegas to the shooting.
If the defendant will please stand.
Within moments, he'll find out if he goes home with his family or spends the rest of his life in prison.
In the District Court of El Paso County, Texas, 409th Judicial District, the State of Texas versus Daniel Villegas, number 94-0D09328. Verdict Form B. We, the jury, find the defendant Daniel Villegas not guilty of...
For the first time since he was 16 years old, 25 years ago, Daniel Villegas is a free man.
Mr. Villegas, you have been under many conditions in this court. You are no longer under any conditions in this court. You are free to leave. Good luck to you, sir.
That is unbelievable. When I sat next to clients where the outcome is going to change their lives, and it is amazing the pressure on them that day. It is hard for any of us really to understand the power of the jury. By the way, next time you get a jury summons, do me a favor. Instead of throwing it in the trash, consider this. Someone who may be not guilty and is going to get off if you don't show up. Someone who maybe is owed millions of dollars that will change their family's life because someone else hurt them may not get it if you don't show up. You have a chance to do justice. It's the only time in our system where you directly impact the process. When you vote for someone, you're not making decisions. You're voting for someone who goes to vote for the legislation. You don't make the laws. This is the one time you directly impact your neighbors, your community, and almost everyone who does it hates doing it on their way in and is glad they did it on their way out.
Have you ever had any moments personally where you had to support somebody from, like they were crying and they can barely support themselves because they're super emotional like that?
Such a good question. I've had a lot of tears. I had a mistrial where my client tried to go after the defense lawyer physically. I had a case where I got a call from the judge to come back to court because my client had allegedly threatened to shoot defense counsel. Allegedly. Client may or may not later have confirmed or not confirmed. that happened. Allegedly, he was heard saying it on the way out of the courtroom, not directly to defense counsel. So I've had a lot of emotion in both ways, but I don't remember any time I've had to literally keep people from collapsing. But that guy, well, they say 25 years. And by the way, for everyone out there's like, well, he confessed he did it. I would never confess that I didn't do it. There's a book called You Have the Right to Remain Innocent. Go ahead and read that book. So we want our police to be good at their job. We want our police to be able to get confessions from people who did it. But you see what you look for in life. And a really good officer getting confessions can get confessions from all kinds of people who didn't do it. I don't know if this guy did it or didn't do it, but I just want you to know that there is lots of evidence where DNA eliminates any possibility that the confession was a legitimate confession. People confess to stuff they didn't do out of fear all the time. You know, the Central Park jogger case where all those kids confessed to something they absolutely, with absolute certainty, did not do, and they all confessed. A confession is a piece of evidence. It is not a video with DNA that leaves no doubt. That's not what it is.
Now we head to Cleveland, Ohio, to the Cuyahoga County Common Pleas Court for the sentencing of convicted serial killer Michael Madison. Madison's been convicted on 3 counts of aggravated murder for the killing and mutilation of 3 young women in Ohio. As part of the hearing, Van Terry, the father of one of Madison's victims, steps up to the podium to make a victim impact statement. Mr. Terry's now just a few feet away from the man who so brutally took the life of his daughter, Sherelda.
Right now, I guess we're supposed to, in our hearts, forgive this clown who's touched our families, taken my child.
He's looking directly at Madison.
Everybody wanted him to land a really good blow when that man went airborne. Now here's the thing. If the court doesn't prosecute him, then do we encourage more of this? If the court prosecutes him after what happened to him, is the court heartless? These are the decisions that are really like beyond belief tough. What do you think? I would love to see in your comments. I'm really curious how you guys think we should handle this, because man, it's a tough call. I didn't know what was about to happen, but when he went off, I was hoping to see a really good hit land.
I know you don't do criminal stuff, but have you ever seen somebody try to attack somebody else in court in your experience?
That one client I held back. The funny thing is, we thought we were winning the case. The other lawyer asked for a mistrial. The judge granted it. I think the judge was wrong. The judge granted it. He didn't go full on airborne. I just had to push him back, try to move him out of the courtroom. He was so mad for a lot of reasons. But the funny thing is, that person, cool as a cucumber, not a hothead, just in that moment, was pushed too far, so to speak.
Van Terry is released without charges. A short time later, County Judge Nancy McDonnell hands down Madison's sentence. Michael Madison is sentenced to death and will now live on Ohio's death row. We start things off at the Russell and Wayne County's Family Court in Kentucky for a hearing on a domestic violence order filed by a husband against his ex-wife.
You and the respondent were married in the past and have children in common, correct?
Yes, Your Honor.
And were the statements you made in your petition true and correct at that time?
Yes, Your Honor.
Are you willing to make those statements part of your sworn testimony here today?
Yes, Your Honor.
I was a judge pro tem in my county, which basically means I filled in for judges when they weren't there. So I don't normally do this kind of stuff, but when I was filling in for, it was actually a county commissioner, and I had to take some of these, and these are the craziest stories. Sometimes you don't know who to believe. You have to make a decision right then, and it's a big deal. I had a family that was trying to get for their daughter an order so that someone she went to high school with couldn't be within whatever it was, like 500 yards, so they couldn't go to the same high school. You have to dig deeper to figure out what's actually going on here. Usually at these things, only one of the people are there. So you got the person accusing someone else there. You got to listen to what they say, and if you don't give them an order of protection, if something bad happens, you got to live with that. So these things are much bigger than they feel when you're just watching them on TV.
Yes, Your Honor. Things have been escalating, I guess, since the first of the year, and Melissa's had a couple MIWs and a couple arrests, and she got out of jail in, I guess, April, and she started, we hadn't really had anything personal up until that point. She got out of jail in April, and she started.
My personal life is your business, John. It has nothing to do with
Miss Hardwick,
no.
You will be held in contempt of this court if you become disruptive.
I don't care. I haven't done anything to this court. I haven't done anything to him.
She will be arrested for contempt of the court.
It doesn't make any difference.
You will serve 10 days for contempt of court.
What do you guys think of how quickly the judge just held her in contempt? Yeah, she was rude, but maybe he's lying. We don't know. Maybe this process is foreign to her. When she said, you can hold me in contempt and then explain I haven't done anything to this court, there was no delay, no let me explain it. There was not, it was just straight to, all right, arrest her. But you gotta show respect to the court. I'm really curious what all of you think. I understand where she's coming from, but me personally, if this is a lawyer who says that to you, if a lawyer says to you, hold me in contempt, the lawyer knows exactly what the lawyer's saying. She has been up against mental health issues that same year. She may have someone that she thinks is lying. She tries to be respectful and saying, hold me in contempt. You're in contempt, now you're in cuffs. The judges have the power to do that. I don't know the whole story. To me, I would like to see a judge as the person who is like the pillar of our legal community, who stands for the respect we have to give a little more leeway and explain the situation. Maybe even instead of the order of however many days, just say, all right, I'm gonna bring you over to the side. I'm not thrilled with how quick that trigger was.
Go now.
On the other hand, maybe she can read it. To be honest with you, that just backs up what I was saying. Just hear me out. That woman felt like, you're literally cuffing me. I haven't even done anything yet. Like, what is going on? And then she lashed out. I still think you could have given her more grace. I admit that now what I just said looks slightly less valid since she just leapt across. Add the judge.
Get off of me!
Hands behind your back.
I got her. Wait and see.
Got her? Shut your mouth.
You.
Shut your mouth. Brace your
Get my bracelet off the
Shut
floor.
your mouth.
Get it.
After spending nearly 5 months in jail, Melissa Hardwick pleads guilty to intimidating a participant in a legal process. She avoids any further jail time by agreeing to a court-ordered diversion or rehabilitation program for 5 years.
5 months, do not attack a judge. Don't do it.
He's under oath from the start of the trial.
No, I'm not. I'm not under oath.
All right, raise your right hand. I'm going to swear you in.
I'm not under oath.
Raise your right hand, please.
That's your bad finger. I didn't appreciate that.
You're going to threaten me like you did the other day?
Threaten you to participate here.
No, you threatened my life the other day. I am not under oath. This is being done unconstitutionally. Y'all took my kids unrightfully.
People love that. Let me tell you something. If your friends around you are telling you that the courts do not have the power under the Constitution to hold you accountable and bring you in or arrest you, you need new friends. This is like a growing movement of people who think they can cite the Constitution as to what they can't do. The courts have power, whether you like that they have power or not. By the way, also don't flip off the judge, I'm just saying.
Allow my witnesses here. You won't allow my paperwork. Y'all took all my court paperwork.
We haven't started the trial yet.
It doesn't matter. You still deny it. You want to take my kids from me and act like that? You and that. You and the bitch that took my kids.
Holly, make sure you take down what I say. He was sworn in.
No, I was not sworn in.
Yes,
I've never been sworn in this court. Bring the camera back. He's making this up.
So that being said, number one, I need to know whether or not you want to be here during the trial process.
No.
All right. Do you want to testify though?
No, I don't. This is all being done unconstitutionally, unrightfully.
Do you want to be in the room or not?
Do you want to?
I'd prefer not to.
But you got to out for it.
See how cool the judge was? I'm not saying he had to be, but it was a good answer.
Here, why you take their kids. This is a conflict of interest. Every right y'all I supposedly have you violated. Can I get some more, please? I got a lot more cussing to do, and I need to drop wet mouth.
Do you want to be here when the jury's here?
What the do you think?
I don't know. I need you to answer.
It seemed like whoever was in the audience there had like a handheld camera.
It was weird.
Is that normal?
So generally, courts have to allow the cameras, and when they allow the cameras, they tell you what you're allowed to do. My last trial, there was a network that wanted to come in and record it. The judge made an order as to when they can come in, where the cameras can be. Usually they don't want any cameras on the jury. If the judge allows someone to hold up a camera, it's all good. You're not even allowed to usually bring out your cell phone and do any video without a court approval. There's good reason that we allow people and cameras in the courts, because it is bad for society if things are done in secret. Because people can go to prison and no one knows what happened. So the government has a lot of power. That's what the court system is, part of the government's power. We want to make sure they're transparent so they can't railroad people, so they can't do it politically, so they can't do things wrong. So the importance of allowing people in the courtroom is huge. Now that we have cell phones, the importance of being able to look at our phone and see what's happening in our courts is super important. If it's only the people who can show up in court, we lose some of that transparency that keeps the government accountable to make sure things are done right. But it's still got to be done in a way that's respectful. So it's really unusual to have a handheld camera like that. Either the judge didn't allow it, which is less likely, or the judge said, yeah, that's fine, which is not the norm, but it's the judge's courtroom, whatever the judge wants. And there was no jury there, so a handheld is not as dangerous. If there's a jury there at that time, that's a problem.
Foxman Justice Center in Daytona Beach, Florida.
We're ready to go for Keandrea, Cook, Judge. All right, Ms. Cook, come on up.
The woman being sworn in is 18-year-old Keandrea Cook. Cook's in court today to receive a sentence for using a dating app to set up a robbery that ended with another teen being shot. The teen survived. Cook has accepted a plea deal that will drop a conspiracy charge, which carried a maximum penalty of life in prison. But counts of carjacking, attempted carjacking with a deadly weapon, and felony battery are still in play.
All right, come on up, Ms. Cook. You get to say the final words.
Okay, before she speaks, remember what I said in other videos, I'm gonna say it again. The judge has a lot of power. Know your audience and know your goal before you speak now. That's all I have to say about that. I fear, because my team is showing me this, that I'm not gonna be thrilled with what she says.
I just want to say that I'm sorry to the people wrong that her son had to get shot, because I didn't even know he was going to get shot. My boyfriend and his friends get threatened me to do this. I didn't even know what was going on until I was at the wrong place at the wrong time. I just want to say I asked her for forgiveness for a second chance so I can get out and finish school. And I can put my mama proud, because I want to be her first child to bring home a high school diploma. And I just want to make my mama proud. That's it.
Cook now prepares to hear her sentence as her loved ones look on.
Ms. Cook, you're before the court for sentencing. A couple of things going in your favor. One, you didn't hold a firearm during these episodes. The second is that the victim luckily survived. That being said, this was intentional. It was an orchestrated ambush, and you are a main part of that. And for that, I'm going to go ahead and adjudicate you guilty of all 3 charges, sentence you to 20 years in state prison. Concurrent as to the first 2 counts.
The crying you hear is coming from Cook's mother. The sentence much more severe than they expected.
Craziest part about these courtrooms is that sitting on the other side of the courtroom are the victim's family a lot of the times. And they're in the same room together, hoping for the opposite results.
It turns out that Cook and her mother's reactions were so intense because they believed the plea deal meant no prison time. Judge Foxman allows her to enter a new plea deal, citing miscommunication between Cook and the assistant public defender. As a result of that new deal,
I think he got good in you, and I think he got potential. Don't lose sight of that.
Cook's sentence is reduced to 11 years in prison.
Whoa, that's crazy.
We head now to Jackson, Michigan, to the 4th Circuit Court. A personal protection violation hearing is on against this man, Jacob Larson. The defendant's accused of sending unwanted advances through Facebook messages to this woman seated here, a former high school acquaintance. This incident's a violation of a restraining order against Jacob.
All those messages were like, a lot of them were like last year. Let me ask, how many of them were after, I asked her, how many of them were after the date of the PPO?
22.
22. I don't post on that much. What's that? I don't post on that much.
This is the second time the judge has questioned the defendant about his contact with the plaintiff. In fact, the same judge had issued the defendant's original PPO 4 months earlier.
Yeah, I know, but it's like this fatal attraction kind of stuff that I warned you about last time. I told you to just leave her alone. She was a classmate of yours. She apparently has no interest in seeing
I want her to tell me to leave her alone.
It doesn't matter what you want. See, because you're a defendant for violating the law, you are now under court restrictions. So you don't get to dictate what she tells you. You know how you know she doesn't want you to contact her? By the fact that she filed an order against you and keeps coming to court. Probably a sign she doesn't want you to keep sending messages.
And apparently that didn't get through loud and clear. So today, you're going to jail for 3 days. And the next time you violate it, you're going to jail for...
You and her are all...
Hey, you know what? You got a bad attitude. You had a bad attitude last time you were in court. Okay?
You and her are buddy-buddy. Y'all get along. Y'all are...
45 days county jail.
Woo! We just went from 3 to 45. That's a lot of ping pong in the county right there. Oh my goodness.
93 days in the county jail.
Whoa, just stop talking, dog. Stop talking. Shh.
You want to go for a year? Try it right now. One more word out of you, it'll be a year of county.
Over Facebook. Really?
Over violations of my PPO and your conduct in the courtroom. 93 days in county.
The judge, clearly agitated by the defiant defendant, is sending him to jail.
I ain't never threatened
Stand
her.
up. Cuff him. Stand up. Yeah.
Buddy.
Stand up. You're going to jail for a year in the county. 365 days county jail.
Look, the judge coming down off the bench, unnecessary, probably a bad choice. Why put yourself in the middle of it? Why escalate it? Why even allow them to later argue that you were, not administering justice and it was personal? Stay on the bench. You have a bailiff. No reason to come down, even though this guy has done everything he's done and talked in a way he shouldn't talk to you because you're the judge.
Appeal it.
I will.
Good. Put your hands behind your back.
Tell me
Now.
to leave you alone. Tell me to leave you alone. Tell me right now.
Put your hands behind your back. Put your hands behind your back. Tase his ass right now.
The judge now steps in to help subdue the defendant.
We'll make it 93. You can think about it. All right.
Over Facebook.
You know her. Well, so I know her. That's not in the community. Get to know you all too much. I'm a good person. That's all right. 93 days. Really?
Larson sentenced to 93 days in county jail.
I want to see if something happened to the judge.
Can't tell me to leave you alone. Can't tell me to leave you alone.
I guess you never know what a judge might do.
Because the bailiff seems like he was having a hard time subduing that guy, is it normal to have more than one bailiff? Or what if that gets out of hand and something happens?
The hearing that this is about is such a low-level hearing. The likelihood that anyone's going to jail, let alone fighting it 93 days, this was never going to happen. You can't possibly have enough bailiffs around for what could go wrong. We just can't afford it. We don't have enough judges. We don't have enough, in some cases, enough courtrooms. We don't have enough court staff for things to move the way they're supposed to move. And we don't put the money into the system it takes to actually make the system a priority. So not having enough bailiffs or only having one bailiff, not a surprise at all. But the right way to handle that is for the bailiff to call for assistance, the judge to call for assistance, bring more people down, right? Not for the judge to generally get off the bench. And by the way, for the judge to say to tase him, that is not your call, judge. You are not a bailiff. You are not a police officer. That is not your place. But he was so mad, understandably, by the way. So I'm not like sitting on high going, how could you not? He had a right to be mad, but to come down and help subdue him. And then you got the guy going, hey, you know her. That's a potential bad look as it is. He's in Jackson, Michigan. This is not in Detroit. People are going to know each other. You can't shut down the whole system because someone might know somebody. But it's a big enough city that you don't necessarily or even usually know everyone in front of you as a judge in Jackson. To then come off the bench looks personal. May not be personal, but it risks the appearance of it being personal.
Because they don't always have the proper amount of bailiffs there or whatever. Let's just say in a fictional scenario, that guy grabbed the bailiff's gun and turned around and injured or killed somebody. Would the court be liable for not having the proper security measures in place for something like that to take place?
There is a lot of immunity afforded to the government. The question would be in that particular state, is there immunity? If there is not immunity, if there's not full immunity, there's only qualified immunity, which there would probably be some. There would be a higher standard than just negligence in many cases to say, is there more they should have done? Whether they'd ultimately be liable if someone sued them would depend first on whether they even legally have a right under immunity. The government gives itself a different set of protections protection that gives the rest of us. And number two, just because someone says you did something wrong, whether you did. So in Arizona, about 11 states of the country are pure comparative fault. Even if they're at fault, what percentage of fault was theirs versus the shooter? In most cases, people are going to blame the shooter more than they're going to blame court staff. Many states have fault where if there's two defendants both at fault, even if there's different percentages, if one can't pay, the other has to. So in that case, the court could be fully on the hook. It is a great question with a complicated, depends what state you're in, answer. From one trial lawyer to all of you, I want to say thank you for watching. Please like, follow, please comment. I want to know, subscribe. Don't forget to subscribe. We're trending. We're going to, before you know it, have 10% of you who are watching subscribers. Just click a little subscribe button. Now listen, before you leave, check that out. YouTube saying, look, here's some cool clips from the court with a trial lawyer who actually does trials, sitting there talking about it. If you want to see more, click this here. Thank you for joining us. Make sure you let us know what you'd like us to go over next time.